afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our guest. If you have a question, please type it into the comment section underneath the video, and we will be sure to address it. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today with us, we have Gregg Luther, who you all know. Gregg has joined us several times in the past, so please check out those episodes as a refresher after today's episode when you've got some time. Today, he's here to talk about admitting the system failure in medical malpractice cases, which is a topic he will cover, and I believe it's the theme of the medical malpractice seminar in September, which will be held in Seattle. As always, we will put his contact information in the description below, so you can reach out to him with any questions about this or other things KTI after this episode. All right, Gregg. This is a particularly topic for me, so let's get into it.
Oh yeah, let's get right into this. What a beautiful undisclosed location there on your Montana ranch somewhere.
Yeah, you'll have to guess if it's a filter or is it real life.
It is real life. I know it is because I can see the grass moving in the backgrounds in the breeze. So what a beautiful place you got there.
Yeah, it's beautiful. This makes working just in a stressful profession a little bit better.
Oh yeah, no doubt. Well, that's awesome that you've got the ability to do all that and still go back to Seattle and practice law.
Yep.
So yeah, here we are again, and a topic that everybody, including me, runs into trouble with, in prosecuting these cases and trying to obtain justice for our clients. And it's the admissibility of the hospital negligence, not the nurse negligence, not the hospital employee negligence, not the doctor negligence, the hospital's own negligence, the big corporate structure negligence. So where it starts, and you wouldn't think that this would be a problem, but it is for the judge. A judge has seen plenty of cases of doctor did this wrong, nurse did this wrong, so hospital, you're liable. The judge has seen that case over and over again. Some judges have seen and understand the hospital system failure or the corporate negligence in some instances, the independent negligence of the hospital. But that's the problem we run into. And since the judge hasn't seen it before, they're more apt to try and not let it in. So we've got a huge hurdle there with educating the judge. And by the way, it's all the law. And not plugging, but you can buy this on Amazon. It's the negligence, purpose, elements, and evidence, the role of foreseeability in each state. And this is a book that I took part in as I was an associate editor. Lee Peoples, the other executive editor, he was at the time the dean of a law school. Vicki Lawrence McDougall, bless her heart, has since passed on, but was a very esteemed torts professor. The foreword by Robert Henry was a former 10th Circuit Court of Appeals judge. So, this was an all law book. And Jenna, do you know that part of our audience is the defense bar?
I recently learned this. Yes.
I apparently get a lot of popularity. Hi, defense lawyers. So good to have you as well. Mm-hmm. But I get a lot of popularity. I'm real popular amongst the defense bar. with these podcasts because it's one of the things they can access. But I want to tell all you defense lawyers out there too, I want you to go buy this book and I want you to read it. And the next time you try and oppose my pro hoc motion into your state, I've never had a pro hoc denied. I've never been disciplined. I've never had a pro hoc revoked, just so you can know that as background. But I'm probably going to try and seek sanctions against you if you don't quote from this book in your state when you're telling the judge that my senior partner, Don Keenan, wrote a book called Reptile in 2009. Because I didn't write that book. I wrote this book, which is all about the law. Get it, please. But we'll start with the law, and I know a lot of plaintiffs lawyers get sick and tired of hearing me talk about the law, but it's where we always have to start. So get your state jury instruction on the hospital's independent duty to their patients. And because if there's one thing the judge probably has seen before, it's that instruction. That's something a judge is going to encounter. So, what's our rule? You guys know our rule is never ambush the judge. Always give the judge the law in a brief and show the judge that you're on the right side of things. Hopefully they'll read it. Hopefully they'll understand it. But the one area that they're most comfortable with, because they see it all the time, are the jury instructions. So start there. Pull and read all the cases that are in the annotations for the jury instruction and, find the areas of the law in those cases that support what you're doing. And then go out and find, the other cases that talk about the independent duty of a hospital or the corporate duties of a hospital. And have those, in a trial brief as well, briefed and discussed, and copies highlighted for the judge, because it happens in almost every case where the judge doesn't understand this, which is quite frequently. And judges, I'm not picking on you. If judges are watching too, I'm not picking on you. This is an unexplored area of the law, and I want to blame the plaintiff's bar for not using this avenue and educating the bench better. But it is an area of the law that is very plaintiff friendly. The hospital wants to pretend at trial that they're just a hotel, basically renting out rooms to these doctors to do procedures or and they staff them with nurses that are like maids just to come in and clean up after the doctors. And that's, if you let that story be told by the defense, it's hard to win your case. But that's not what hospitals do. Hospitals are federally and state regulated because hotels are just in the business of, letting people sleep for the night. And in most situations, not a life or death thing, find a place to sleep at night. So, but going into a hospital is a life or death thing. So it's much more closely regulated, and their responsibilities are higher, and the laws and regulations on hospitals are way more strict than hotels. So that's the next place after. So number one is jury instructions. Number two is case law. Number three, I want you to go to your statutory law and get all that and pull that as well and familiarize yourself with that. It's the only way, it's the only road to get your clients to full justice in the case is educating the judge on the law. I can't guarantee you that even though you do all your work, I can't guarantee you that the judge will do the right thing. We've all been there. We have all been there. If you haven't been there, you haven't tried enough cases. But you'll do yourself a bigger favor in convincing the judge if you get them the law and the jury instructions, case law, and the statutes. So where do you go? Where's the good place to find statutory law on hospitals? Well, I've tried cases in multiple states. Dawn's tried a case, at least started trial in almost every state. And we have found that it's universal. It's in the state administrative code. So in the state administrative code are all these rules and regulations for hospitals. And for those of you that haven't read them before, it's going to be a pleasant surprise for you because you're going to read it and think that a bunch of plaintiffs' lawyers wrote these things. It says hospitals have to be careful. It says hospitals have to watch over their staff. It says hospitals have to make sure that they have the right number of staff. It says hospitals have to make sure that their staff is competent. All these great things that, I'm sorry for letting the cat out of the bag, hospital defense lawyers. You can quit watching now because it's not going to get any better. But that's where the real rubber meets the road on making hospitals accountable in these rules and regulations in your administrative code. And like Jenna said, hey, we're going to Washington in it's the first ever Keenan Trial Institute Medical Malpractice College. And it is this has been a challenge. So this has been the most requested thing since we started asking people at the Mid-Mal seminar 8 or 9 years ago, what do you want? It's always been, we want a college course just on medical malpractice. And I'm like, that, impossible. No way, too much work. Well, because what I thought originally was there's no way for us to teach every class, jury selection, opening, depositions. There's no way for us to teach every class in a med-mal college. But then I thought, what if we taught in addition, when you're doing a med-mal case, in addition to what you learn at the college, this is what you should be doing for med-mal. What if we just taught that? So that's what we're doing at the Mid-Mal College in Seattle, is we're assuming everybody's got some foundational knowledge of the Keenan Trial Institute undergraduate and graduate courses, and we're going to take that foundation, we're going to build on it with the extra things that we do in medical malpractice cases that's been proven, time tested, at trials with focus groups. We're going to first time ever, put that out there. We'll see how it goes. I'm really excited about it. I've almost everything is done now as far as preparation, and I'm really excited about it. So we'll see what people think of it afterwards, but hopefully, and we've got pretty good registration is pretty good right now, but we still, we've got room for more people. So please, if you're watching this sometime between now and September 11th and 12th, and you do med-mal cases, it'd be worth your while to come. It really would, because we're gonna give you tools to take home and use. Some you use right away. Some are going to require skill development, but a large part of what we're going to handle is what we're talking about today, and with the hospital accountability, separate and apart from the nurse and the doctor accountability. So getting back to Washington, if we go to the Washington Administrative Code, and I've pulled a few that we can look over right here.
And the nice thing about Washington's, which I don't know how many others have this, but this applies to not just hospitals. We have hospitals, we have ambulatory surgical facilities, we have clinic, there was a successful the lower courts are starting to kind of get this a little bit better. But there was a corporate negligence claim upheld against a physical therapy clinic just recently. Not at the appeals
Awesome.
level. It'll go up there. But, remember, the doctor works for someone. They're not an individual going around carpetbagging their surgeries. So,
Right. 100% right. That's a great point. Somewhere, whether it's a clinic or some sort of surgery center or whatever, they're all governed by some set of rules and regulations in the administrative code in every state. It doesn't matter. I've heard lawyers for years now. I've listened to, our state doesn't have that, whatever, and I can look it up and find it in front of them. It started out with when we were talking about foreseeability for, how careful you have to be is determined by the foreseeable harm. And they were like, well, our state doesn't have that. And I'm like, really? And then, of course they do. We look at it, and that's what's in this book. That's what's in the book. So if you're a doubter, get the book. I don't make a dime off the book. The law school owns all the copyright. So, Keenan Law Firm, Keenan Trial Institute, Gregg Luther makes nothing off the book. It's all going to advance education. So anyway, I told you, if you read these things, you're going to think that it looks like a bunch of plaintiff lawyers wrote these. But anybody who wants to be a hospital, they have to provide for what? Oversight responsibilities. So they have to be, checking in to make sure everybody they turn loose to, work on patients or touch patients or treat patients or bring things to a patient in a hospital, they have to make sure that that's, I can't believe they use this word, Jenna, but these lawmakers said they want safe patient care. And
yeah,
I hear defense lawyers.
I mean, that was crazy in, the recent case I had is that everybody agreed. The statutes, the Department of Health that came in and visited the facility, the 30B6 witness, everyone, these are in place for patient safety, for patient safety, for patient safety. And I'm like, okay, then why do we not care when it's violated? It's very interesting.
Yeah. Or why, the biggest thing, they do care, and and jurors put that responsibility on the hospital. Lawmakers are just, for the most part, regular people. And they put that responsibility on the hospital. Hey, open up your hospital bill, see who's getting paid the biggest amount. It's not the nurse. The nurse isn't getting paid anything. The doctors, are making pretty decent money, but most of their practices are bought out by the big conglomerate hospital groups now. So these big conglomerate and some, private equity and hedge fund groups are even buying into it now. And do you think the quality of care is going up? Not based upon what we see in the I start thinking about the people we represent, and this. I think the reason people ask why I get so animated when I talk about this stuff, and I think the reason is because I've sat across the table from too many parents or widows or orphans, parents that lost a child or have a devastatingly damaged child now, or children that don't have a parent any longer or have to watch their loved ones suffer and die. I've seen that too many times. So I know there are, we have opposition out there that say we're just all about money. But I will tell my opposition and all the healthcare providers in the world this. I'll issue this challenge today. Put me out of business. Put me out of business.
Yeah.
Quit committing malpractice once and for all. Quit harming your own patients. And look, I would love to not do this anymore. I'm at a point in my life where, I've had a fair amount of success, and I can do something else. I can, go out in my boat all day and, I could find peace and happiness there. I, for some reason, have felt this calling ever since I was young, that I need to be involved in, not a spectator, I need to be involved in accountability and obtaining justice for people who've been wronged and have no way to make it right. So anyway, enough of my high horse, but put me out of business.
Please do. I'd love to
Yeah.
retire. Please.
Yeah, put us all out of business. I don't want to see any more devastation. These are human lives.
It's awful.
These are real human lives. I don't care how jaded you get, and and what you do. These are real people, just like the rest of us, who, were hoping for the best and trusting their hospital, their doctor, and were, let down, tragically let down. Anyway, back to the law. Safe patient care, defense lawyers. It's in your state administrative code. Hospitals have to provide safe patient care. Go look it up. Stop lying to the judge that the standard of care has nothing to do with safe patient care. Stop lying to the judge, because there it is. You're looking at it on the screen right now. So that's straight out of your administrative code. This wasn't written for plaintiff lawyers to go prosecute, doctors and hospitals. This was written so that all patients could leave the hospital in better or the same condition as when they came in. That's all we're asking for. But the governing authority, which is whatever the hospital board or whoever's in charge, they must do all these things. And part of it is they've got to establish and review policies with the minimum requirements. And of course, Washington has a great law on informing patients of unanticipated outcomes, which, by the way, if you've got that law and the doctor wants to talk about, well, this is a known complication. Well, did you tell the patient about it beforehand? And did you explain it to him afterwards, in compliance with Washington law? Because they always want to bring that stuff up, but they want to use it as a sword. But here, it's our sword. It's our sword to use. C, I want you to focus on C, establish and approving a performance improvement plan. If there's a gold mine in hospital policies and procedures, the Joint Commission calls this the Patient Safety and Performance Improvement Plan, and they require that every hospital has it. And I know, here's why I'm not going through the Joint Commission standards, is because in a lot of states with a lot of judges, they don't feel safe enough letting us use Joint Commission standards because the hospital, didn't create those or whatever. Well, here's the law in your state, and it says the same thing, exact same thing. The law in your state says this hospital has to have a performance improvement plan. And in that performance improvement plan, or patient safety and performance improvement plan, the hospital says we will, of our own accord, go throughout our whole hospital and rid it of all the dangers and all the possible places where patients could be hurt or killed. And we'll just make sure that doesn't happen. And we'll do all we can. And when we change something, we'll monitor it to make sure it's better. And we'll, not only that, we'll look into our other policies, even though nobody's been hurt, and we'll, make sure that those are still good as well. And we'll do this at a minimum of once a year or twice, once every 2 years or whatever. They say all that stuff that we want them to be doing. When we see a policy in a hospital is just grossly inadequate and out of date, they're going to have this performance improvement plan, which said they should be doing all that. E, reporting adverse events and conducting root cause analysis according to what? Washington law. We know they don't do that. And so many, where they hurt or kill patients, bad hurt or kill patients, sentinel vent. They don't do that. If they did, that would, you know, that's what they should be doing. And if they would be doing that, there would be a lot less. They could almost put me out of business. I'd be happier. I wouldn't have to talk to so many unfortunate people. I mean, just this week, I have talked to two mothers whose babies died in the hospital. It's gut wrenching. Whether they have a case or not, it doesn't matter. I still go through the same emotional roller coaster, and listening and developing a care, caring for those people and feeling their loss is terrible. In both cases, mistakes were made. Both cases, I don't know that if everything would have been done by the book, that in the one case, I don't know if the baby would have survived. The other case, I'm leaning towards a yes. But in both those cases, a case where there is liability and a case where there probably isn't legal causation, both families are still devastated. Both of those parents are, that scar is lifelong, and they'll carry it to their grave. They'll be reminded about it at every wedding, every graduation, every, college football game. I don't care what it is. Everything that they go to, every birthday party, everything, that scar is going to go with them whether they have a case or not. So, for all you defense lawyers who think that we are just doing this for the money and some profiteering motive, I want to, I'll challenge you to do this. Follow me around for a week. Take these calls, take these intakes, sit across the table from these people. I hear all your speeches when you're in a deposition. We're so sorry, no matter how this turns out, and all that crap you say, but you really don't have to see it. You don't go to their houses. You don't see their lives day in, day out. I will ask all you defense lawyers watching, I'm going to ask you this. By all that's holy, do not request the deposition on the date the decedent died. Whatever their date of death is, make sure you don't ask for that, or make sure you know their birthday and you don't ask for that either. And make sure you know the anniversary and don't ask for that. Just stop doing that. It's, and all you plaintiff lawyers know that too, and don't go to your clients and ask them for that date. It's horrible, and it happens way too often to me for it to just be an accident. It says a lot about the kind of people that, are asking for that kind of stuff. Okay, so enough about the high horse stuff. H, communication and conflict resolution between the medical staff and the governing authority. There's going to be fights and arguments between doctors and hospitals. They've got to provide for some way to resolve that. But 5 is the most important. They got to review and establish bylaws, rules, and regulations for the medical staff. And in the bylaws and the rules and regulations for the medical staff, you're going to find a lot of gold as far as accountability for not only the medical staff, the doctors and the lower level providers, nurse practitioners and nurse midwives and PAs and all that. But you're also going to find responsibilities for the hospital, because remember, up at the top of this list, when they establish policies, they have to, what did we say? They have to do oversight. There, the nice little word is right there, oversight. So they've got to do oversight of those too. But we all know what a stop sign is if the policeman isn't out there enforcing it, right? It's just not a stop sign. Everybody, only people like me who just stop no matter what are going to stop at that stop sign. Everybody else is going to run it until there's a cop there, waiting to hold people accountable, hiding behind the, tree or whatever. If they weren't there, if there wasn't any oversight, the laws would just cease to exist. There's got to be oversight. There's got to be policing going on in the hospitals. And the beauty of it is your state law says that has to be in place. So that's governance. Now let's talk about leadership, which is going to be, now we're going to be dealing with, CEO, nurse executives, and different boards, in the hospital, and the executive medical executive committee, that kind of stuff. That's what leadership is in the hospital. Now, again, these aren't Joint Commission standards. We're going to be in Washington, next month. So I try to tie it to, most of our people signed up are from Washington, try to tie it to stuff they can take home and use. So they've got to assure that care is provided consistently throughout the hospital in accordance with what the patient and the community needs, right? Which that's pretty good. They got to have a nurse executive, director of nursing, all these policies, these care policies, they got to approve those. And hospital-wide care service is appropriate for the patient served and available resources, and that includes department specific, so like surgery, OB, whatever. Integrating and coordinating patient care services, standardizing the uniform performance of patient care processes. That means policies and procedures that everybody has to follow, right? And some of these others I've highlighted, but I want you to focus on number 3 because it's a goodie. Adopt and implement policies and procedures which define standards of care for each specialty service. And 4, practitioner oversight. Watch over these doctors and midwives and nurse practitioners and everything else and make sure they're doing their job right. So, if the hospital policies by state law have to define the standard of care, then whatever the hospital policy says according to state law must be standard of care. Now, you don't get there just yet with that. You still need to have an expert witness who's, going to meet your state qualifications in Washington. You know how to thread the needle there, folks, but every state's a little different. In Washington, your expert, has to, be knowledgeable of the standards of care, medical care in Washington. Right, Jenna?
Yes, and if they practice outside of Washington, best practice to meet that goal is to have them have a phone call with somebody in Washington of their same specialty who can confirm. Like if they cannot come in and say, hey, I know that Washington standard of care is XYZ because that's the national standard of care, not good enough. They have to know and have confirmation that it's actually the same in Washington.
Yes, good point. And I mean, the Supreme Court recently said that.
Yeah, the Morimoto case.
Even though all the medical experts come in and say, even the defense experts, neurosurgery is a national standard of care, but that doesn't get you there. But you got to have a qualified expert who says that this policy is consistent with the standard of care. Now, where you get on this is the defense has a hard time arguing that the policy doesn't have to be followed and it's not the standard of care when the law says it needs to be. Think of the cross-examination fun you could have with this. They try to do it anyway, but here's your backup, folks. And I know A lot of people may be venturing into their first med mal case, or maybe don't do a lot of them, or haven't done one in a while, but it's okay. That's what we're here for, is to help you. Your clients deserve the very best lawyer, and we're going to give you those tools. So, but here it is. Hospital policies define the standard of care. So saith the Washington legislature. Or actually, I don't know who promulgated these. Jenna can tell me if I'm wrong. Um, but again, adopt and implement policies and procedures addressing patient care and nursing practices. So that's, again, something your leadership has to be doing through all their different committees and nurse executive and director of nursing and everything else. Require that any contractors who come to the hospital abide by the hospital's policies and procedures. And then, just other things that'll be helpful to you if you do this kind of work. So, who do we got? Who do we got piping in here?
Let's see. We've got Mississippi's statute says rule blah blah blah. Well, maybe I'll say it because maybe people from Mississippi are listening. 15-16-1-41.80.2 provides performance improvement activities must track medical errors and adverse patient events,
Good point.
Their causes, and implement preventive actions and mechanisms that include feedback and learning throughout the hospital. The question is this information discoverable?
That's a good question. Their policy certainly is. So what we typically ask in a case is, did you do a root cause analysis? Yes or no? The peer review privilege, takes a lot of this. It makes it not discoverable, and we have to abide by the law. Like I said, abide by the law in your state. But you can find out if they did one, and you can find out what their performance improvement plan is. What they're supposed to be doing. It's going to have a lot of stuff, again, about patient safety and about eliminating errors and policing and stopping preventable patient harm before it happens. That's really what that's useful for. But yeah, you should be able, we can almost always get them to answer whether they did a root cause analysis or not.
Yeah, it's just the substance of it, the outcome, those sorts of things. But
yeah, I've even gotten where they took where they clipped a doctor's wings on privileges. I've gotten a judge to let me see, what the new delineation of privileges was for that doctor after the sentinel event and root cause analysis. So I did get that, that happened prior to the malpractice. In the actual malpractice, that was the focus of the case, though. So, but yeah, you can definitely get their policy. Can you get their root cause analysis in the case? I'm going to say no. If you get it, it's probably error, and you're going to end up trying that case again, even if you do get it.
I wonder, if I don't know if it's getting too far into it, but you might ask just the corporate representative, what tell us about your performance improvement activities. How do you track medical errors, adverse patient events? You'd ask them about all that stuff, and then was that done in this case, kind of a thing. And obviously, if you're getting bad answers to the general stuff, that's not good, but it's helpful to us. So.
Yeah, these are more, so this stuff, what I want you to do with what we're talking about today, since we're talking about admissibility of this kind of stuff, is this is more for educating your judge and educating your experts. Educating your experts so that they know where the boundaries are, where the in and out of bounds stuff is. Give your experts your jury instructions. Give your experts your case law on it. Give your experts your administrative code. This is all going to help them. If they don't have to rely on Joint Commission standards, then, a lot of times the judge won't let an expert testify about Joint Commission standards, but I don't know of a judge to date who's prohibited an expert from talking about, the state law that requires these things.
As long as they can do it as it framed as the standard.
Right.
I've had judges fight me on experts being able to talk about the law because they're not lawyers and they're not the jury and they're not the judge. But if you frame it as here's the standard, and this
right.
is coming from the
and
law.
this, yeah.
Yeah.
And this is the, here's the support and the basis for that opinion.
Mm-hmm. Yeah.
It's the law,
Yeah.
And so hospitals must adopt and implement policies and procedures to define each patient's right to be treated and cared for with dignity and respect.
Mm-hmm.
Your expert can say a hospital must do that. The basis for that is, this statute. But you can also, if you're a state where you have negligence per se, or if you have and a negligence per se jury instruction, or if you have case law that says violation of a statute or regulation can be, admissible as evidence of negligence.
Mm-hmm.
Again, know your case law. You can use this stuff in your jury instructions. You can get the judge to instruct on it. They've certainly done that before, not in a med-mal case, I get that, but they've done it in, car wreck cases and those sorts of things. But patients' rights and organizational ethics, what a great title. And this is where, Don has a saying that every med-mal case is an informed consent case until proven otherwise. And it's either an informed consent case or it's a patient's right case. Because patients have a lot of rights, and Medicaid and Joint Commission require that. And what I want you to, I want you to focus down there at the bottom of the page. Hospitals have to provide a written statement. Or not that part. They want to, here. They have to post it on their website. Mm-hmm. So they have to post their patients' rights on their website. And there's a lot of rights that are good for us. They got a right to be, told the right information. And again, here's the word safety again. I'm sorry, defense lawyers. I apologize. But it says safety again. And plaintiff lawyers did not write these, I guarantee it. No. So this is, they've got this does include informed consent, but it goes a lot further. It's the hospital saying you have these rights. And then they also say you have these responsibilities. And somewhere in the responsibilities, almost every one that I've read, it says the patient has to follow all hospital policies and procedures or hospital rules that apply to them. So if that's the case, how do we let a hospital off the hook for saying our nurses don't have to follow our policies? Yeah, the patients do. And we make them sign something, say they're going to follow them. And if they don't follow them, we can kick them out. But no, our nurses don't have to follow that. They can use their nursing judgment. That's really being a hypocrite there. And it just sort of shows you how ridiculous that defense is. It's not the word I want to use, but that's the word I'm going to use right now. Okay, so they've got to have the patient's rights and they've got to display it. Oh, when you're doing discovery, folks, one of the things you should request in discovery is every document your patient signed. Because one of the things that they don't include as part of the medical records is the patient's bill of rights that your client signed, probably around the same time of admission. You need to get that because it's going to help you. It's going to say a lot of the things your experts are going to say anyway, and it provides the basis for their opinions. All right, so just for example, I picked obstetrics out of here. We do a lot of obstetrics and we do a lot of pediatric, neonatal cases. But here's, department specific. If you're going to have obstetrical service, you have to have somebody to do C-sections 24 hours a day. What do we see so often? They're, pitting the dickens out of a mom. Her uterus is clamping down because of the Pitocin. The uterus is clamping down like a boa constrictor on the normal unborn baby. And you end up, no C-section done because it would take too long to call everybody in at 2 a.m. Well, turn the Pitocin down, and give the baby a breather. Turn that boa constrictor juice off. Let the baby get some oxygen from the umbilical cord, the lifeline. Anyway, got to be able to do it 24 hours a day. Doesn't say 22. Doesn't say not on Sundays.
Only during business hours.
Yeah, but that's true. I mean, that's what's so frustrating about this is we know what really goes on. And if you're not going to do that, then you just have to limit your admissions to the low risk patients as defined by Washington law. So it's going to tell you where the boundaries are. The nurses don't get to use their nursing judgment on this one. This is the law says what you have to do. Then you have to, staff with all your right people and look at number 3, look at number 2, define the qualifications and oversight of the staff delivering the obstetrical care. So hospital, you're not off the hook. You're not a hotel. You should be hospital if you do these things. Defense lawyers, if your hospital does these things, you'll put us out of business. Just right now, I'm giving you the roadmap to put us out of business. Do it. I don't want to talk to any more of these moms and dads. I don't want to see any more of these kids that can't say a word, can't sit up, who are, 6, 7, 8 years old. Don't want to see it. Number 3, standards of care, policies and procedures define the standard of care. If you've got a policy and procedure, it's got to define the standard of care. So there's no more, well, we leave that to the doctor's independent judgment. We leave that to the nurse midwife's independent judgment, blah, 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 blah. You can't get by with that. That is not I know that defense has worked for years. Trust me, defense lawyers, the plaintiff bar in Washington did not conspire with the lawmakers to do this. This is just normal stuff people want done so that, moms who go to the hospital with 9 months of doing everything they were told to do, embarrassing, humiliating things they were told to do, and every checkup, normal, every test, normal. For 9 months, they did that. They should be able to go into a hospital and that baby delivered and be normal. Still, if mom did it for 9 months, hospital, you can do it for 9 hours or 2 days or whatever it's going to take. You can do it. And it doesn't take that much. It's easy to do. But here it is. It's the law. It's the law that you got to do at hospital. So if you just won't do it for altruistic reasons, by the way, if you won't, take your religious symbols off your hospital. If your decisions are being dictated by your hedge fund or conglomerate owner, take your religious symbols down. We know there are no sisters at Mercy anymore. Don't call it Sisters of Mercy. We know it's bean counters there. Um, your jurors know that too. Stop trying to capitalize, or if you want to, do all this stuff. What would Jesus say to do? This. Be careful. Don't hurt anybody. Do unto others as you want to be done to, you want to be treated, golden rule. All right, enough of my high horse stuff. So let's talk about neonates then. And this is, you guys know where this comes into play, but a baby's born, a baby's, blue. A previously normal baby is now blue, limp, no respirations, no heartbeat or little heartbeat, no reflexes or very little reflexes. And it's time for, the neonatologist or the, whatever, whoever's there to come in, the team to come in and be heroes and save this previously normal baby prior to, the Pitocin being turned way up. Same stuff, they've got to do the same thing. Implement policies and procedures. Hospitals must. Again, this isn't hospital. You don't get to decide what you do and don't want to do. The law says you must do these things. It's the same stuff. The qualifications and the oversight of your staff. Hospital, what are you going to do to watch over them? Again, number 2, hospital policy. They must use hospital policies and procedures which define the standard of care. No, neonatologist judgment or respiratory therapist independent judgment stuff. Sorry, that's not an exit door. That's not a defense. The rest of the stuff is, have the right people there. Make sure you have the right people there. Okay, so now we've gone over. I'm already out of time. Dang it. We've talked about we do what?
It goes quick.
It does. Now I'm just now getting to the good stuff. So we talked about jury instructions. We talked about case law. We talked about rules and regulations. You got to have a list. The only way to give your judge comfort, folks, is to give them the law. They need the law. Your experts need it too, as the basis for their opinions. But the judge needs the law, and the judge needs it early. So let's talk about this just for what time is left. And if you want to stay late, I'll go over. I don't care. To me, it's important to get this information out to folks. But so feel free, if you got a question, put it in the chat. But here, these are guidance documents that are put out by the Washington Medical Commission. So this is what the doctors' licensing, accountability, and leadership group is telling doctors. And this is another thing. I mean, you should be quoting this in a trial brief and giving this to your judge. And not only that, this is like a brief, because what are they citing? Case law, right? This is, your judge is going to look at that and go, okay, here's the Washington Health Law Manual. I mean, these are not things, folks, that a bunch of plaintiff lawyers got together and dreamed up. Informed consent is not merely signing a form. It's a dialogue, which, information concerning the risks, benefits, and alternatives of the test or treatment, not just surgery, being recommended. Obligation is rooted in the patient's autonomy, the patient's decision-making. They have the right to make decisions about their own bodies, basically. My body, my choice. The practitioner, this is from the case law, must supply the patient with material facts which they will need to intelligently decide what to do. Their destiny with dignity. That's pretty good language there. It's the kind of stuff that we harp on all the time. Let's look at number 3 and I'll stop. Number 3, this is what the organizations that license and polices doctors in the state of Washington says. you have to make sure your patient understands. So what do? You explain it to your patient, and you say, now explain back to me in your own words what you understand. And then, did they document that in the chart? And ask your client, did the doctor, make sure that you understood? Did the doctor have you repeat that back? Because all too often we know, how that conversation goes, if it happens at all. And there's just not much of it. So, that's the other thing I want you to have ready for the judge so that you can be well educated. You're not going to like the last part, but I want it to be less than 2 pages. Have all this stuff in a brief, less than 2 pages, and it's really just one section in your trial brief. So, that's the difficulty we all face, is getting this into evidence. Judges are not familiar with it. They will be, but the only way they're not going to go along with you because you say so. They're going to go along with the law, and you have to get them the law so that they understand. All right. Any more chat questions?
Any come through? Anybody have questions out there, folks?
Oh, I don't know that we get them. I think she gets them. Okay. So, hey, Jenna, it's so good to see you again. Thanks for all you do. It is a thankless job, I know, but you are, such a valuable asset to getting this information out to people so that they can use it and be better lawyers for their deserving clients.
Well, I'm happy to know that defense lawyer. Oops, am I frozen?
No, you're going.
I'm happy to know that defense lawyers are downloading and transcribing this stuff, because I'm happy for them to know that this is what they need to do.
Yeah.
And maybe judges are looking at it. I mean, that would be fantastic. I think it's, you all seriously, we do this publicly for a reason. Like, learn from it and make the community safer, make hospitals safer, make clinics safer, make physical therapy clinics safer.
Yeah.
Because you don't want to get sued. So just stop getting yourself sued by doing the stuff that's just easy to not do,
Right. And the worst consequence, do it so you don't get sued, but do it so you don't hurt or kill, your patients. That's not too much to ask. You're not stocking shelves at Walmart. No offense to people that do. I go to Walmart and I want the stuff to be in the right place.
Right. But you don't want to your head either. There's a lot of personal injury cases with bad stocking at Walmart. So it is an important job. But
yeah, it's an important job. And if you mess that up, though, nobody dies or gets hurt bad typically. But it's not that way with healthcare. It's totally different. So, okay. So folks, if you stuck around this long, thanks. I hope to see you in Seattle, September 11th and 12th, 2026. On the 13th, I'm going to do a free workshop for people that want to stick around and work on their cases and put some of this to use. There's also, if you're a paid up attendee, there's a free little buffet sort of mixer the evening of the 10th. So hope to see you. Jenna, I love your beautiful ranch. Enjoy it. Say hi to your husband and pet your dogs for me.
I will. Thank you, Gregg. Say hi to your loved ones as well.
I'll do it.
And thank you, everyone who joined us today. Thank you for asking questions. Thank you for listening and paying attention. And thank you for anyone who inadvertently stumbled upon this. And hopefully you spread it and teach hospitals and medical facilities how to be safer, and other lawyers how to get justice for their clients. If you liked the episode, please click the thumbs up, feed that YouTube algorithm. Don't forget to subscribe and sign up for alerts so you don't miss an episode. And you all have a wonderful weekend. I'll see you next time.